Senator Molari.
I have listened, Mr. President, passionately to some of my distinguished colleagues on this matter, and the philosophy behind this bill is very laudable. It's laudable in that the alternative dispute resolution is the way to go in this day and age, with a view to decongesting the courts. On at least 2 occasions, we've had cause to come here to increase the number of judges. The Federal High Court Act and the Court of Appeal Act, those bills were sent to the Committee on Judiciary with a view to increasing from 70 to 90. And we have also noted how long it takes for electoral matters to get sorted out at the tribunals, and it affects the courts, because the judges that will sit at the tribunals are taken from these courts. I was initially of the view that that was what the leader meant when he was going through the lead debate, the penultimate paragraph, when he mentioned that alternative dispute resolution mechanism into our legal system for an effective and efficient criminal justice system. This will bring about radical reduction of the backlog of criminal cases in the judicial system. I agree entirely with the latter, but not the former. Like Senator Eta Enang said, it has to do with mostly commercial matters, civil matters. However, if we promote it, it will decongest the courts. It will assist the criminal matters that are pending in court. It saves cost, Mr. President, saves time, saves energy, and most times there are clauses that are enshrined in contractual agreements. My challenge, however, is that already a lot of states are going into this alternative dispute resolution matter. It will also take a lot of money to set up. I do not agree that because the contributions can be taken from people, irrespective of whether they will compromise at the end of the day, that it will be self-sustaining. It cannot be self-sustaining. Section 5 of the bill provides for even the setting up of state centers. 36 states and Abuja will also have alternative dispute resolution centers. And after all, what is the bill proposing? It's proposing the regulation of accreditation. I don't think it is necessary, Mr. President, for accreditation of alternative dispute resolution bodies to be regulated. I acknowledge the fact that this commission is not on its own an ADR body. It is a commission that is meant to regulate. Yet, there is no need for any regulation. It will advise federal and state governments on issue of the mechanism, develop policy, and so on and so forth. It will amount to another white elephant project. We will have yet another body that people will be reporting to. I'm also conscious of the provision, Mr. President, of section 4 of the Constitution, most especially section 4, subsection 3, which provides the power of the National Assembly to make laws for peace, order, and good government of the Federation with respect to any matter included in the exclusive legislative list. There are 68 items on that list. It is not part of it. It is also not part of the concurrent list. The concurrent list is the one provided for under section 4 that says that if there is a clash between laws made in that respect, between the acts of the National Assembly and the laws of the Houses of Assembly, it is the National Assembly's Act that will prevail. However, it is always clear, and I think I must say this, it is not at all times that even if a matter is provided for, that under the concurrent list, that the National Assembly has exclusive right to make laws therein. I will give an example. The issue of item 11, which has the marginal note E, electoral law. The National Assembly may make laws for the Federation with respect to registration of voters and the procedure regulating elections in a local government. But item 12 now states the powers in respect thereof when it has to do with the State House of Assembly, which provides that nothing in paragraph 11 hereof shall preclude the House of Assembly from making laws with respect to election to a local government council, in addition but not inconsistent with the laws made by the National Assembly. The fact that it is concurrent does not mean it is not specific. They are always specific. They always provide for powers to the federal government and also powers to the state government. If we also go further, Mr. President, sir, the issue of electric power, which is 13, the National Assembly powers is provided for exclusively under the concurrent list for the National Assembly. And the 14 now provides, item 14 now provides powers under the concurrent list exclusively to the State House of Assembly. However, even under the concurrent list, I've not seen anything that gives power of alternative dispute resolution to the National Assembly. So I am just of the view that we should, at this stage, when we are even thinking of cutting costs, despite how laudable the issue of alternative dispute resolution is, I know, for instance, that after setting up Citizen Mediation Center, Office of the Public Defender in Lagos, they went ahead to set up the multi-door court room system, which is an opportunity for you to first of all ventilate your opinion once you file processes. We agree. A lot of times it may just be very little issues that are bringing them to court and that they can easily resolve. But I think the states are doing very well in respect of this matter, and there is no need for us to go into this. There are so many bodies already. There is Chartered Institute of Mediation and Conciliation that is regulated. They conduct examinations, they train people. There is the Chartered Institute of Arbitration. There is a Nigerian body, there is a UK body. A lot of Nigerians belong to the UK body. There is a society for construction industry arbitration. In final analysis, I think we should not pass this beyond this stage. I oppose it. Thank you very much.
All right, thank you.